Welcome to Behind the Neon Lights, Understanding Personal Injury Law in Las Vegas and Beyond.
Welcome to Behind the Neon Lights, Understanding Personal Injury Law in Las Vegas and Beyond with C. Jared Clark, owner and founder of Clark Law Group, specializing in auto collisions, motorcycle crashes, and personal injury law, and dedicated to helping clients every step of the way. My name is John Clements. Today's episode is From Injury to Courtroom, How a Personal Injury Case Really Moves Forward. First of all, Jared, as always, hey man, good to see you.
Hey, likewise. I appreciate you having me.
Well, let's dig into it because this is an important one. Especially if you find yourself in this situation in a personal injury case and you have to go to trial, you're going to want to know what's in store. So let's just talk about that. First question for you, Jared. After someone hires you, what's the first step your firm takes to begin building their case?
So the first thing first is we put the insurance companies on notice that we're representing the client, and that way they know to seize any and all communications with the client, right? Sometimes they try to do sneak attacks and get things very early on because they know that the client may go get an attorney at some point, or the potential client may go get an attorney at some point. Right after that, we launch our investigation, and that's where that's the front end of trial, right? To say the least, or a different way to put it. We are seeing, was there a police report made? Was there any witness statements made? Was there any statements to the insurance company made that we need to request? Was there any video surveillance that captured the incident? Is there any other type of evidence that maybe we need to get a preservation letter out to make sure that they preserve and store the evidence? So those are things, it's really the investigative phase that you start the moment you get that case.
Nice. And for the record, I would hire you just to not have to talk to the insurance company. Like that by itself is, where do I sign?
It's worth it. It's akin to like having to go to DMV and sit for 6 hours, right? I think that's a great analogy. It's a miserable experience because they're terrible. They really are.
Yeah. Now, a little bit off the point, but I do want to ask, once the insurance company realizes they have to talk to the lawyer, does that change anything with how they address you or what they're saying or what's on the table?
I believe so. Not all the times. Obviously, that varies from adjuster to adjuster and sometimes insurance company to insurance companies. But oftentimes it does go to a different person and or department within the firm. So they're like, hey, this person is attorney rep. There's going to be a new adjuster assigned to it. Sometimes, if a person doesn't get an attorney, it just stays at the team level.
I see. So they get to talk to a special person. I see.
Correct.
So talk to us. So we've kind of briefly discussed the beginning of what you do for the clients. You start kind of running interference with the insurance company. You start documenting the case. So talk to me about the general timeline then. Like how does that look from treatment either to settlement or to a trial?
Yeah. So there's a few different phases. I like to say, after you got the investigative phase and kind of that runs simultaneously with that is your treatment phase. So obviously the client has been hurt. They need to seek medical care, right? We have to prove that the client has damages, AKA some type of medical care, emotional damages or whatever it may have. You see a doctor, you undergo a course of treatment, right? That may be 2 months, 3 months, 4 months, 5 months, 6 months, who knows? It depends on the severity of your injuries, right? Is the treatment helping? Is it getting worse? Are they properly identified? What's the pain generators? And then at some point, you're going to reach what doctors call MMI, maximum medical improvement. Hopefully you reach MMI. And that's where the doctors discharge you. And that's when your case goes into the next phase. And that's the gathering of all the evidence or the medical records and the bills. Okay. Once we have all the documents, we have any witness statements, the police reports, the medical records and bills from all the doctors, it goes into the next phase, which is the demand writing phase, to go ahead and draft that demand package. And that's just a pretty legal package that pretty much explains our theory of liability, and it attaches all the evidence that we have to support our claim. Okay. And then we send that to the insurance companies. And then generally after that, we get into what's called negotiations with the insurance companies. And then if the case resolves, it wraps up. If not, a lawsuit oftentimes will go ahead and prevail or proceed after that.
So that's a lot.
Sorry about that. I should have gave you the
No. No, it's totally fine. It makes sense to me. But my point is, like, it sounds like this is going to take some time. Like, this is not something that's going to resolve itself within a week. So are there like estimates that you would use to say, okay, generally to get to settlement, it takes this long, or to trial, it takes that long? Or does it really depend on many other factors?
It depends on many factors. I oftentimes tell my clients I hate trying to give time frames because once you say it, they're going to either one hold you to it, or number two, sometimes they mishear things, right? So I oftentimes say, hey, on average, it could take between 9 to 12 months, but I oftentimes emphasize that that's just an average. So that means sometimes we could settle before, and there's a lot of cases that fall outside of that. And then I give the different reasons of why a case could settle quickly or cases that are more drawn out. But it really does vary. It's a case by case basis. It really is.
Got it. And then I did want to circle back to you. You mentioned a demand package, and I think part of that is probably something called a demand letter. So that's the first I've ever heard of these terms. So I was hoping to get a little bit more explanation about kind of what's in there and why it's so important to a personal injury claim.
Yeah. A demand letter and package is what a personal injury attorney in other spaces, areas of law, they send it to. But we send to the insurance company and we demand a sum of money, right? It's to go ahead and initiate negotiations, right? And what's in that is typically our theory of liability. So we have the Nevada law. We tie the facts to it. This is why you're at fault legally. And then we identify what are you at fault for? Okay, what are the harms and losses that happened to my client? Right? What were the medical bills from this chiropractor, from this radiology facility, from this surgical facility? Was there a police report or any other ancillary type pieces of evidence? If so, we make those exhibits to the demand letter and the demand package and put what's inside the demand package. So things of that nature, there's obviously could be a lot more. Any photographs of the damage to the vehicle to show how severe or significant the property damage was, right? What was the actual estimate? Was it a total loss? We attach that piece of information to the demand letter as well. So it's just an array of different pieces of information and evidence to show and paint this picture for the insurance company of, hey, this is what has happened to my client. Here's the legal reasons why. Here's what you're responsible for.
Okay, that makes a lot of sense. And that was, I don't know what my conception of demand letter was, but it wasn't that. So I'm really glad you specified that. Like, oh, that makes perfect sense.
Yeah, the word demand doesn't really give off any connotations of what it is or
Yeah.
yeah. So
I mean, it sounds kind of mean, like you're just being mean to them. I don't know.
I know, right?
So you've got this demand letter, which has basically, it sounds to me like it's kind of the fruit of your investigation. Here's all the facts. Here's what we believe happened. Here's the opening salvo in the negotiations, and that's kind of where we're at. So then at that point, you're either looking at a settlement or maybe taking a case to the trial, it sounds like. So how do you decide, or do you decide which route you go, whether it's settlement or trial?
It's a case by case scenario, right? Some cases go to trial, some cases go to mediation, some cases go to an arbitrator, and some cases settle. The bulk of cases settle, right? Probably somewhere between 90 to 95%. Depends on a lot of different things and what jurisdiction you're in. But if the settlement offer is fair, based upon the information that has been submitted, right, that's a good reason to settle, right? Because there are always risks. So typically what we do is we do a cost benefit analysis and we explain that to the client. Hey, here are the risks in moving forward. Here's the settlement offer that's on the table. And then we let them know this is a great offer. And how do we kind of define great offer? Obviously, a personal injury in Nevada has been here for a long time. We get to see what are juries awarding, what are the different arbitrators awarding. We could kind of find a baseline based upon what similar folks have went through. What were their diagnosis? What treatment did they receive? And then, kind of what was their pain and suffering claim? And we could kind of get these ranges that help us identify exactly, what was this person's harms and losses worth.
I see. So along with that, one of your values for yourself and your company, we talked about in a previous episode, is this idea of treating people like family and really caring about them. So I'm curious to know, as part of that cost benefit analysis, does emotional trauma fit into that? Like the person says, I just don't want to endure a trial, or like, how do you work through that?
Yeah, I let the clients know, and it's their choice on whether they want to settle, go to trial, mediation. We are here, I tell the clients, we're here to do all the work based on our training, education, and expertise. However, the big decisions to settle your case. What do you settle the case for based upon the offers on the table? Do I go to trial? Do I not go to trial? Us lawyers don't make that decision. That lies within the province and the power of the client.
Oh, so that's interesting. So like legally speaking, like they decide, and you're just saying, here's all the facts. Whatever you decide, I will support.
Correct. And we obviously give our recommendations, right?
Sure,
Our professional recommendations and opinions, and go through that cost benefit analysis and make sure we're laying out all the scenarios depending on which way you go, so the client is fully informed. But if let's say Allstate puts an offer on the table for $25,000 on a case, right? I can't just say, hey, I accept that. I have to communicate that with my client, and they are going to let me know whether or not, hey, I want to accept that, or here's what litigation looks like. Hey, Jared, do you have authority to file a lawsuit on my behalf?
And so then do you ever have to support a client when they maybe make a decision that you maybe personally wish they wouldn't have made?
Yes, that happens at times, right? And there's also times where, sometimes we reach an impasse, of just, we can't advance their best interests anymore for a variety of reasons. So yes, those scenarios do also come about. While it's very far and few between, that is a real thing.
Yeah, but I think it speaks to your integrity to realize that and to still act in their best interest, even if, there's maybe an impasse or a disagreement about what that even is.
Right.
Yeah. There's another legal term that I'm hoping you can help me with, because it's another of these terms that sounds kind of scary to me. It's the word deposition. Like, oh my gosh, like what did I do? I'm in big trouble now, right? So talk to me about depositions and what a client should expect when they find themselves to be a part of this process.
Right. So, yes, depositions, it's very daunting for most people, and understandably so. We just conducted one a couple of days ago on a slip and fall case. And basically what a deposition is after a lawsuit is filed, you enter this part of a court or litigation that's called discovery. And that's just a fancy word for the attorneys are exchanging information and evidence. Okay, so we're sharing information and evidence that we have on our client with the other lawyer, and they're doing the same thing. Well, during that process, the Nevada rules of civil procedure, they allow for you to take depositions of people and parties, right? So obviously the defendant, the person who caused the accident, and the plaintiff, the person bringing the action seeking damages, the other attorney is allowed to take their deposition. And what a deposition is effectively, it's an examination under oath. It's an interview under oath is the best way to put it, right? So let's say one of our clients, they're going to have their deposition taken from the attorney who's representing the at-fault driver in the insurance company. And that attorney is going to have the right to ask my clients in that deposition about their injuries. How did the accident happen? Did you have any prior injuries before this accident? Have you been in any prior surgeries? Are you claiming future pain and suffering? Are you claiming that, hey, you're going to need future medical costs from this case? So that's a deposition. And your lawyer is there to protect you during that. And your lawyer also preps you before that happens. So, you know exactly what a deposition is, what questions they're likely going to ask, and you're prepared to answer those to the best of your ability.
Okay, well, that was definitely my next question is, hang on a second, are you there to help me? Because
yes.
I don't want to walk into that without being prepared.
That's part of our job. That's one of the most important parts of our job.
Nice. And do you feel that, is that a combative situation, or is everyone pretty professional on those settings?
It's both. We've seen it all, obviously we're dealing with people. We all know people. Right. And naturally, the civil justice system, right, what we do, it's adversarial, right? It is very antagonistic, So depending on who the attorneys are involved, there could be fireworks at times. And then you can have the very civil ones, the very diplomatic ones, the very reasonable ones. So like, hey, we're just here to get some facts out of you, some information so we could do our job. Right. And then you have the ones that are very combative, sometimes on the verge of harassment, or sometimes you have to suspend depositions just because, they have it out for you to just be an a-hole.
Yeah, for real. I want the other kind, please.
Yes. Most people do.
Yeah, and I want you in my corner if I ever have to do it.
We got your back, John.
All right, cool. All you have to do is move to Nevada first.
Just come
All
when
right,
it's cold out there.
All right, cool. Last question for this episode. We talked about this is a long, arduous thing to be involved with, the personal injury case and take it to settlement or to court. So what do you want people to know as clients of your potential clients about staying patient, trusting the process, trusting you guys that you have their best interest in mind?
That's always with a lot of clients, it could be a challenge because I think naturally Americans are impatient, right? I'm
What?
guilty of that at times, right? I do a lot of I travel the world leisurely for just to learn other cultures and this and that, and I oftentimes come back and like Americans are much more impatient than a lot of other cultures and countries, but it is what it is, right? I tell clients I try to lay out their expectations or our expectations of them from the consultation, right? I think that's when it's important. And even throughout the case, we remind them of the expectations. And the biggest one, and the one that we remind clients the most of, is this is a process. This is not going to happen overnight, right? Your injuries aren't going to heal overnight. We're not going to be able to get you a settlement overnight. It's a process. And sometimes some cases take longer than others, right? And that's just, it is what it is. So I try to let them know you are signing up for this. And oftentimes, justice takes time, right? So, let us fight for you. Trust us. We've been at this for a while. And, sometimes having your day in court is what it takes, And, so just trying to get them comfortable, trying to get them on board, trying to say, hey, still try to live your life. And we understand you got other obligations, this and that. Let us kind of do what we do on the back end. But it is a process. So we will never be able to change that.
Yeah. Unfortunately, it's just the reality of life. So Jared, as always, Jared, it's just been such a pleasure to talk with you, to learn from you about all these areas of personal injury law that most of us don't know because we're not lawyers. So thank you for coming on the show today, man.
Hey, thank you for having me. If you're ever in Vegas, you let me know.
I will, man. And to our listeners, thank you for tuning into Behind the Neon Lights, Understanding Personal Injury Law in Las Vegas and Beyond with C. Jared Clark. To connect with the team, head to injuryattorneyvegas.com. Be sure to like, subscribe, and leave a review. And with that, have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.